popping the recording on. Thanks very much indeed, Marie. Much appreciated. So today I'm going to talk to you about testamentary capacity. I'm going to talk about why it matters to your charity. So let me just start the presentation. So this talk is being brought to you by Capacity Vault and Make a Will Online. It's a little bit about us. We started working around making wills and protecting people's wishes online in 2008. Today, as I say, testamentary capacity. I'm going to kick off with the 5 W's, who, what, why, where, when, around capacity. I'm going to talk to you a little bit about some of the detail about what capacity means, what testamentary capacity is under English and Welsh case law and in practice. I'm going to talk to you about what you can do about it. I'm going to focus as well on why it matters to charities, the potential problems that it can cause, and how to ensure that you build a resilient long-term testament gifts in wills campaign. I'm going to say who should do something about testamentary capacity and their wishes. I'm going to say where a supporter can go if there is any concerns around potential future challenge to their wishes. And I'm going to tell you when the supporter should take that action. Starting with, what is testamentary capacity? Testamentary capacity is a series of tests that were set out by a very old case. It has been examined and re-examined in the courts hundreds of times, and it's always been found to be good law. The case of Banks versus Goodfellow asked 3 questions, or 4 questions, to determine whether somebody had testamentary capacity. First 3, whether someone had sound mind, sound memory, and sound understanding. What that means is sound mind is checking that they know what a will is. Do they know what they are doing when they are signing their will? Sound memory means, do they know what they have to give? Do they know what they're about? Do they know if they're a multi-millionaire, or do they know if they're a pauper? And gifts that they leave in their will should reflect that. And sound understanding is, do they know who should be inheriting from their estate? Do they remember their partners, their children, and others that are closest to them? There's another limb of the estate which went out of fashion for a while, but recent case law has started looking at it much more carefully, where it says that somebody making their will should have no insane delusion or disorder of the mind. Now, that is very 1880s language, but recent cases have dealt a lot with grief and the immediate aftermath of grief. Normally, when somebody has lost a spouse or partner or child, and the fact that their affections towards others closest to them may be grievously affected by that. It's important to say that the test is not the same as the test under the Mental Capacity Act. If somebody is a Mental Capacity Act assessor, they would be applying the wrong test as to whether somebody has testamentary capacity. So if anybody is in doubt, do apply the testamentary capacity rules, which can still be passed even if someone lacks capacity under the 2005 Act. Why does it matter? Well, there was something just a week or 2 ago in the Beeb about dementia cases. They're set to increase. Issues around testamentary capacity are going to increase with it. Families can have sad histories, and when somebody dies, it's often the money left in a will, which is seen as a substitute for love during a lifetime, and people will fight for that after somebody is gone. Also, you have to bear in mind the fact that people who do not have capacity should not be making a will because of the risks to those that are genuinely closest to them. Why this all matters? From our perspective as practitioners, when we make a will, what we are doing for somebody is giving them peace of mind. When a supporter makes a will and leaves a gift, they are seeking the peace of mind that knowing that their wishes are going to be looked after. If there is a question mark, or if there is somebody in the wings who could query someone's testamentary capacity, that supporter needs to think about it to get that peace of mind. We need to think about the risk of a challenge. And if somebody does not consider testamentary capacity at any point in the proceedings, whether that's from your webpage talking about wills through to the practitioner making someone's will and just overlooking that aspect, you could be opening yourself up to challenge. So it should always be considered. Where there's a challenge, there are enormous financial implications. At the very best case, you may have to devote time and effort to talking about supporters' testamentary capacity. And if that testamentary capacity, if they're found to be lacking testamentary capacity, you wouldn't get the gift they would otherwise wanted to give. If you were successful, you would still get the gift, but you would lose out on the time that you've devoted to dealing with that challenge. And there's reputational issues around taking a challenge forward to court. Successful or unsuccessful, there are certain segments of the press and of the other media that delight in reporting challenges around gifts to charities. So we want to deal with testamentary capacity from the outset to avoid any of those implications. Now let's get to the crux and focus down a little bit more and talk about who needs to consider testamentary capacity. I said earlier, everybody, and everyone should, but there are certain segments of your supporter base who should be thinking about it more than others. And that, again, comes from case law. I'm going to talk to you about second of three cases in this talk. Re Simpson, in a judgment by Lord Templeman. Now remember his name. In the judgment of Lord Templeman, he said that anybody who is elderly should consider taking action following the golden rule when completing their will. That is very vague. What is elderly? Unfortunately, there's no further guidance in case law about who counts as elderly. He also said that anybody who had suffered a serious illness should take action by following the golden rule and completing their will. Again, what does that mean? If someone had a serious diagnosis in their 40s or 50s, and they're now in their 60s and feeling perfectly well, thank you very much, does that count? Well, possibly yes. Those are people who should be considering taking additional action under the direction of Lord Templeman in that case, Re Simpson. I would add more generally that anybody who is concerned that there could be a risk of a challenge in their will should consider testamentary capacity issues and take action where they can. When there is a challenge to a will, it is very easy just to tag on the fact that, oh, Gran didn't know what she was doing when she made her will. even if she was perfectly able to do so. So if there is a risk of a ne'er-do-well in the family challenging the will, please, please, please do take action. Also, if there's a substantial gift, especially to a charity, somebody should consider it, because that is going to be a trigger for potentially one of the residuaries or somebody else to challenge the wishes in their will. Take action, do something about the risk of there being a challenge to the will. Now, I'm going to have a little throwback to Lord Templeman on the second slide about who needs to consider it. In 1977, Lord Templeman set down his rules on who should be considering gifts and a challenge to their will. In 2020, we see his name come up again. This is in Goss Custard versus Templeman, and it relates to the validity of Lord Templeman's will. Now, Lord Templeman died about 8 years ago, and about 14 years ago, he made his will. So we're not even talking about a deathbed will here. And that will, which was 6 years before he died, was challenged under the for lack of testamentary capacity. So what can we do? Traditionally, in order to deal with the risk of a challenge for testamentary capacity, you follow that rule from Reece Simpson. Follow the golden rule, get a medical professional to act as a witness to your will, and get that medical professional to act as, to take a report when they execute, when they act as a witness to your will. You usually, historically, go to your GP. Now, that is increasingly difficult. GPs are wising up to the fact that if there ever is a challenge, they'll be expected to take time off, go to court, make statements, be cross-examined, and there is guidance to GPs that they should think very carefully before acting as a witness to somebody's will. So where does that leave you? You can go to a private doctor, you can go to a psychiatrist and get a testamentary capacity assessment. That is very difficult to find outside of London. It's also likely to be very expensive, upwards of £1,500. I did a trawl of the internet. The cheapest I could come up with was a testamentary capacity from a social worker who is able to carry out capacity assessments and do so as part of their job. The cost is still upwards of £500 when you take into account travel, etc. And that's beyond the means of most. I want to talk to you later about Capacity Vault. Capacity Vault will take a record of someone's testamentary capacity from any handheld or desktop device. More on that later. It is new. It is a new way of protecting somebody's will from challenge under accusation of lack of testamentary capacity. When should somebody take action? It needs to be done really immediately before or immediately after executing a will. If you've got a medical professional acting as a witness, it will be at the time of taking that will. As more and more things are done remotely, it needs to be roundabout, the time it is executed. If you don't, there are exceptions to the rule that it's got to be done around the same time as executing that will. If you ever find yourself relying on this exception, you are in trouble. It's called the rule in Harker and Felgate. In this case, Mr. Felgate had capacity when he went to speak with his solicitor. He knew exactly what he was doing. Solicitor took a reasonable amount of time to put that will together. By the time that will had been drafted, Mr. Felgate no longer had capacity. Now, for various reasons, the judge wanted to thread the eye of the needle and find this will to be valid. And what the judge found out in this case was that when Mr. Felgate gave his instructions, he had capacity, he lacked it, but even whilst he lacked capacity, he had the ability to remember giving instructions to his solicitor. And therefore, because when he gave those instructions, he had capacity, that will was able to be valid when he executed when he lacked capacity. Don't go there. Don't try and run that in a court. It is an enormous risk. So what the takeaway advice should be from here is just mention testamentary capacity to every supporter. For only they will know their personal situation, their circumstances, whether they've been ill, whether there is anybody out there likely to lodge a challenge. And obviously no one thinks of themselves as old, but they may be able to understand that someone else thinks that they might be old in the eyes of those tests. So at the end of last year, we carried out some research of where will preparation has gone to, which makes this even more stark, even more important. More wills these days are being made remotely. So before the pandemic, only 30% of practitioners, we contacted all of the Society of Will Writers and a fair few solicitors who make wills as well, around 1,500 altogether. We got approaching 100 responses. So 95% since the pandemic have taken instructions remotely. Whenever you take instructions remotely, the risk increases. I did a quick look at the publications from cases from last year. I actually found 11 wills which were contested in the highest courts. 9 of those mentioned testamentary capacity. Now, as I said at the beginning, it's a tag on. If you have a challenge, why wouldn't you say that the person lacked testamentary capacity? And that little tag on might be what got something through to being a dispute rather than being settled in the first place, and the costs that that relates to. So consider testamentary capacity from the outset, and you can mitigate those risks. In our survey, we also found that 1 in 10 professionals took instructions over WhatsApp, desperate to do more research into that, whether that's everything or whether that's just aspects of the instructions, but we will be looking into that. And the takeaway was that of the people who are making wills themselves, that is members of the Society of Will Writers, members of the Institute of Professional Will Writers and Qualified Solicitors, 45% of those were worried about testamentary capacity challenge. I'm going to just mention at this stage, that is what we're going to talk about in respect of testamentary capacity. Has anybody got any questions they want to chip in at this stage about testamentary capacity? If you want to shout them out, please go ahead. If you want to pop them into the chat, please do that, and I'll answer those. There will be more time at the end to do both of those things. If any burning questions.
I've got one question in the chat, Oliver.
Super Marie, what's that?
From Jude, does remote also include online?
So I would say remote wills include online, they include telephone, and to be honest, I would include Zoom calls with that, because when you are not in the room with somebody, you have to note that. And if a will is ever challenged, if a solicitor prepared a will, they have to do what's known as a Larkin Nugas letter. That is a letter where they have to set out what was put into their contemporaneous notes. And if an interview is done online, they have to mention it, and that will inevitably cause additional cross-examination or examination of their notes to see what they wouldn't have been able to cover dealing with something remotely. Online, of course, yes. We've got another question, I think. I can't actually see them, Marie. Can you pop that one up for me? Can you read that one out for me, please? Oh, sorry, I'm going to have to end the screen share and just take a quick look at that in the chat. So this is Annie Atwood, thank you. The solicitors have a set procedure to follow. This is generally to refer to a consultant, work for a Testamentary charity, and work in scenarios. So there is no set scenario. It's a really good question. There is guidance. You know, the Society of Trust and Estate Practitioners have guidance. They have pro formas that people can use when doing that initial interview. The procedure comes from Rhys Simpson. If someone is aged or has been unwell, they should go and get a medical practitioner to go through the steps. That is increasingly difficult to the extent that it's impossible. Even when you have that, the solicitors, the judge might not run with the medical practitioner's notes. There's a case called Scammell and Farmer from 2008. That is where somebody did the golden rule, went and had it signed in front of a medical practitioner, and the judge said, well, you know, medical practitioner says no, but the solicitor's notes said that they had capacity. So the judge did what he wanted to and followed the solicitor, not the doctor. There's another case which involved a well-known charity, the Special Trustees of Great Ormond Street in 2001, and that had the opposite. It said that the will should have followed the golden rule. So really what you need to do is belt and braces, get everything you can in order to protect the wishes of a will. I'm going to segue along through to the next part of my talk here. We've got a few minutes left, and I'm going to tell you about Capacity Vault. Capacity Vault is a brand new service which we have developed. It is intended to protect the will, protect the wishes in the wills of anybody who uses it, and it's intended to be accessible to all. I'm going to tell you what it does, tell you how it does it, and I'm going to tell you who should use it. Here is a short promo aimed at solicitors, in fact, who are going to be adopting Capacity Vault. Or not. Oh well, that doesn't seem to be working with the screen share, so I'll pop onto the next screen. What does Capacity Vault do? Capacity Vault is a way of protecting the wishes in a supporter's will. The service explains what is needed in order to protect somebody's wishes through an online tutorial. It takes a few minutes. It will then record information that a supporter records through the video interface securely, in such a way that we are able to reproduce that secure encrypted recording if a will is ever challenged at court. So how do we do that? User will go through, we'll create a secure account, we'll understand what the user is doing, where they are connecting into us from. We will access the camera and microphone of any device which has a camera and microphone. That can be a tablet, it can be a mobile telephone, it can be a desktop or a laptop computer. And we're going to store the recordings that we take from the user in an offsite facility. We're going to encrypt everything that we take. And it's going to be able to be reproduced verifiably. We use aspects of AI when we're taking the recording, and we use aspects of blockchain technology to ensure that any recording we get is going to be tamper-proof. Now, the supporter is going to get some details of the hash that we use to encrypt their recording. We're going to keep that elsewhere, and there will be physical copies of a certificate with those details on it. So it's pretty much hack-proof and tamper-proof. So any recording we provide will be able to be admitted as evidence, and we will produce the Larkin Nugas letter that solicitors have to produce when they've been in a room with a supporter. We're going to produce that and swear the statutory declarations that we need to in order for everything that we've done to be admitted as evidence. Now, we've designed this system along with leaders in the field of testamentary capacity, including Lee Sagar, a barrister who's part of the Society of Trust and Estate Practitioners, special interest groups on protecting vulnerable and digital assets, so that we can get this to court in a way that they can accept. I'll show you what a recording looks like, I hope. If not, I'll see if I can circulate the recording so that you can take a peek later on. I'm having no luck with the recordings whatsoever here. I think it might be something to do with the fact I'm recording the session, and this is a recording from YouTube. At the end of this session, I'll end the recording and show both of those videos for anybody who is interested. So, sorry, here's the team, some of the team that developed Capacity Vault. There's Lee, there's myself, and there's Alex Hammond, who's a technologist and a will writer, who's been doing this since 2008. Who should use Capacity Vault? I'd reference back to the legal test. Anybody who is aged, anybody who is unwell. You need to consider the risks when you're communicating with supporters. Always err on the side of caution, even if they are not currently aged or unwell. You do not know who might be in the wings wanting to contest a will. And we saw from Templeman, who came up with this rule, that even though he made his will 6 years before he died, it was still tested on the grounds of capacity. So again, throwing back to that earlier question, anybody who's making a will online or on the telephone should be told about testamentary capacity. Anybody who's making a will through a will writer, especially considering 95% of those are now taking instructions remotely anyway, should be thinking about testamentary capacity. Anybody who is preparing a will through a solicitor should be thinking about it as well, because 95% of those are taking instructions remotely. And wherever there's a substantial gift, for goodness sake, think about testamentary capacity and do something about it if you can. And that may well be taking a recording on through Capacity Vault, which will be there. It will be stored and encrypted, and we will be able to provide that as evidence in the supporter's own words when they come through to protecting their will. In conclusion, any will can be challenged. It does not matter if you are a justice of the Supreme Court. Challenges are always disruptive if you are involved on either side. Historically, capacity assessments are difficult to get through your GP or very expensive if you go to a private doctor. And nowadays, there can be concerns around all wills, but what I'd say is this is especially true for wills that are remotely prepared. So Capacity Vault is something which is there, which can protect supporters' wishes. And it's worth us mentioning that Capacity Vault is going to be free to all supporters who are making wills through Make a Will Online's online charity service. Every supporter who makes a will through there is going to be given access to the full suite of Capacity Vault with no extra charge to the supporter or to the charity. It is all included within our free will service. So, has anybody got any questions at this point? I'm going to stop the share whilst we, it's going to stop the recording whilst we go through this. And I'm going to see if I can play those videos to you.